Thank you to Emmanuel there and our amazing speakers. That was a great discussion. And as we can tell from the conversation, it seems like digital securities really aren't going anywhere. So the next question is, how do we move forward from here? Well, that's when the legal side of things comes into play. And navigating the legal landscape really is almost close to navigating a legal minefield. So we're going to jump in a little into the legal side of digital securities and where to hand over. I'm going to hand this over now to Jor Law, who will be moderating this conversation. Let's have a round of applause for our speakers. Yep.
All right, so this is working. Oh, and the room got quiet. Thank you for that. Yeah, so we have an interesting panel, obviously. It's security tokens, and we have to talk about traversing the legal landscape of digital securities. We have a great panel here, so maybe just quickly, 30 seconds to a minute introductions down. Bob?
My name's Bob Cornish. I run a law firm bearing my name. We are headquartered in Jackson, Wyoming, the headquarters of blockchain in America. We work with blockchain and cryptocurrency providers, third parties, other industry participants in the US and abroad to help them leverage Wyoming's robust legislative platform for the digital assets industry.
Hi, I'm Brian Tang. I love crypto events where lawyers actually are kind of little stars here. So I'm a reform lawyer. I was at Sullivan Cromwell beforehand here in New York and in Silicon Valley. And then I moved over to Hong Kong, where I joined Credit Suisse doing IPOs. So when ICOs came about, everybody started looking towards me. I went into fintech, regtech, and law tech, and now I'm at Hong Kong University leading Light Lab, Law, Innovation, Technology, and Entrepreneurship. And part of the reason there in my mind is that a lot of what we're doing, there's less law, there's more policy, right? So we're all actually working together, actually evolving the regulations as we speak.
Hi, Brian Korn. I'm a partner at Manatt Phelps here in New York. Ben Brickner, one of my partners, is also here. I'm the co-head of the financial services group and lead the blockchain initiative. We have a three-part approach to blockchain. One is DeFi. We work with protocols such as Centrifuge, Maker, and Aave. We have a tokenization practice, mostly working with gamer tokens and other people who are putting out free-to-play and other drops and wondering about the securities regulations around what can I issue, where can I do it, with what materials, where do I have to file, what about onshore, offshore, and so we work a lot with our offshore partners. And then the third area is NFTs. We have a thriving NFT practice built mostly on our entertainment work. We participated in such deals as the Fatburger deal, which somebody mentioned. We did the Coachella deal with FTX. We did the Crypto.com NHL playoffs. There's a whole world of these NFTs. One of our clients, Diplo, created a 30-second original piece of music that he made $20 million in about 5 minutes selling NFTs. So a lot of the NFT world is kind of not really discussed or followed, but at least in the legal sense, but really something to pay attention to.
Hi, everybody. I'm Yael Tamar. I'm the CEO and co-founder of SolidBlock, and we are a real-world asset tokenization platform and a bridge to DeFi. And we've been in the market since 2018. We were a part of the first security token for real estate deal, the Aspen coin. So we've worked with, dozens of law offices, regulatory bodies. We frequently sit down with regulators in different countries, in the US, in Israel, in Dubai. So we are a part of this largely compliance space. My background is in finance from Wall Street through M&A, private equity, to very, very heavy funds of funds, public offerings and so on. And I arrived to blockchain basically through kind of my desire to put that financial knowledge onto a more permissive and flexible framework. So, a few things that I would love to discuss. You mentioned NFTs, so we do NFTs for utilities, for timeshare in hospitality, or for use of property. Just really interesting things that would possibly go outside of the realm of securities. And then on the other hand, we do just very, very traditional security products, right? So securities that we digitize through blockchain. So on the intersection of the two, so happy to discuss.
And I'm Jor Law. I'm also a reformed attorney. I was the co-founder of VerifyInvestor, which was acquired by T0, which is a fintech company that, among other things, does tokenization of digital assets and as well as secondary trading. And security tokens has been a topic I've been long a fan of. I architected perhaps one of the earliest security token protocols out there and just have kind of followed the industry throughout. So I'm actually pretty excited about this. I've gone through I started off very pro-regulator, and like these days is maybe kind of less pro-regulator, and I'm sure I'll find my way back a little bit. But since this is a security token summit, and we are talking, about laws, we have to start with kind of the obvious, which is what's going on. The SEC is out there, and they're claiming that everything is a security almost. What is the legal landscape? As we traverse the legal landscape, just across the board, is everything a securities? Like, what's your feeling about that? Should everything be securities? What's the status of the Howey test in light of BlockFi and some of the other actions we've seen?
I'll try and answer that in less than a minute. I think the first problem that the regulators have to deal with right now is the schism between money market vehicles and stable tokens. I think the biggest issue right now for a lot of these folks is how you delineate the two and whether you're marketing yourself as one or the other. Someone who's marketing themselves as pegged to the dollar is definitely going to attract the attention of the SEC, because there are rules about how people who peg certain things to a dollar or an index are going to start running amok of the Investment Company Act in 1940. One of the things I'm sure all of you have had to deal with at some point or another is whether you're running an inadvertent mutual fund or not, whether you have pooled assets, and whether you're running afoul of those rules because you're pooling assets and you shouldn't be. And I think that's where a lot of the rubber meets the road on where things become a security and where they don't. Is what you're doing really a proxy for a security, or is it something else?
I think it's a great question, and a few years ago there was a huge debate over what is not a security, and we're still having that debate. We're all here. The word security is here, so I guess we sort of conceded that we're in that landscape. Security under the 1946 Howey test, which is not a congressional statute, not an SEC pronouncement. It's from the U.S. Supreme Court, and if you follow history, 1946 was sort of an interesting transition in court from pre-New Deal to the Warren Court. But they came up with this formulation that if you have an investment contract in a common enterprise with the expectation of profits derived primarily from the efforts of others, then that's a security. And that was a case that proved that Orange Grove cooperatives were not securities because everyone was working on the cooperative. So fast forward to 2022, we have people who are selling things and buying things where they are expecting profits from others. And the SEC has taken an extremely broad view on what is and is not a security. And we used to give very reasoned opinions and memos that something would not be a security because it fails one of the tests, it's not based on a common enterprise. But after the BlockFi settlement, which if you don't know, a company called BlockFi, which does lending against cryptocurrency. They lend US dollars and they take crypto as collateral. On the other side of that, people can put money into their account, basically stake their crypto and earn yield back. And the SEC said that the yield payments, basically a form of bond interest, if you dumb it down to the real economics, was a security. And the company, I guess, was told strongly enough that this was their view that they paid a $100 million fine instead of litigating or doing something else. So I think that that's a big stop sign for a lot of people, and a lot of people in my industry aren't giving this is a security or this is not a security or this is utility token opinion anymore, because if something that looks like a staking reward can be deemed a security, then most anything can. When you have people who are putting out gaming tokens and they're not asking for money, there used to be an expression within securities laws called the no sale doctrine, where if it's free, it's okay. Google IPO, if you remember, you could sign up, you could get free shares of Google. The SEC said that's fine. Those don't have to be part of the registration because nobody's paying any money. It's a free drop. We're now in an era where asking somebody to do anything, giving them your phone number for texting, giving them your email address, signing up for a mailing list, those are all elements of possible consideration that could make the drop a security. And I think it's difficult when you talk about listing and the future of these tokens in these white papers where you're saying overtly, we're going to be listed on Uniswap or SushiSwap or a handful of exchanges. And I think you're asking for the government to come after you and say, okay, 99% of the people buying this thing have never played the game. So why is this utility token limited to this game? And I think that we're in a very cautious element right now, and I think that's what's driving a lot of the momentum towards offshore.
So I just want to add to that. If it was very clear that's what's a security, what's not a security, then I guess you guys would be out of business, right? The lawyers would be. Well, one of the things, but it's very important to actually for the U.S. companies or U.S.-facing companies to continue to fight the fight, I think, and to actually issue tokens that are not securities, especially if we believe that they're not, if they're clearly based on utility. And the differentiation of a profit versus no profit. There's profit everywhere, right? So we kind of have developed like an approach which, it's not necessarily a legal approach, but at least when clients come to us and they say, we want to do a non-security based on, let's say, 2 weeks in a hotel per year, right? So then there are a few things that we would ask along the way. Is this fractionalized, right? Or is this, or I want to sell a villa as an NFT. Is that a security or not? So we kind of ask them a few questions. Is this fractionalized? Or is it several people buying a villa or just one person buying a villa? Even if you're renting it out and getting profit, right? So there's still these gray areas where we would want to go and try to find somebody who still gives a legal opinion, to be kind of very strict. But I think it's very, very important to continue because there's so many great use cases that might not be a security.
Yeah, maybe we can dive into some of those gray areas, at least with respect to NFTs, right? NFTs are frequently misunderstood by the public, and a lot of people think that, oh, if it's an NFT, it's not a security, but that's not necessarily true. But rather than try to figure out, like in this particular case it is, in this particular case it's not, maybe you guys can talk a little bit about some of the nuances of NFTs and how they affect whether they might be securities or not.
Right, I think the first thing to remember is that an NFT should not be the proxy for a security. And I think there are some folks who have kind of taken the NFT model to a point where it probably where it may not, where it shouldn't be, in that the NFT is actually representative of something that is indeed an investment contract. I think where you have products and services that are bespoke, distinct, especially in the art and collectibles world, all of these things, yes, we can invest in them, yes, they're going to appreciate, hopefully. That doesn't necessarily make them a security. But where I think you're starting to see a lot of the issues come up with the SEC, especially in some of the metaverse things that are coming up, and the casino rulings that are coming out, where people are buying NFTs in a casino, in a metaverse casino, and they're gaining profit or loss based on what's going on in that metaverse casino. That kind of stuff just doesn't sit well with regulators. You got to realize that. It is the world we play in, but I think keeping the management of the asset itself separate from the actual asset itself is probably the delineator for when you cross the line when you're creating an NFT. And I know Wyoming has, taken a pretty progressive stance on a lot of these things, and the state definitely wants purveyors of digital assets to come to the state, leverage all these wonderful things that it has, including a lot of the exemptions for utility and things like that, and tax. But there does have to be a fine line between using an NFT as an NFT and using an NFT as a proxy for something that you really ought to consider a security.
So NFTs are multifaceted. In the DeFi world, most NFTs are not securities. They're conveyance vehicles to send assets to a trust or custodian. In the collectibles world, I get uncomfortable when the NFT is identical to 1,000 other NFTs, and it's being sent away in a drop where somebody's going to be able to get, okay, I have number 700 out of 1,000. Maybe that's worth something because it's a different number, but if they're all the same, then you're really issuing a series of the same type of collectible with the intent for somebody to profit from it. An NFT itself that's appreciated for its own value would fail the Howey test because it doesn't derive its value from a common enterprise. You buy the Beeple NFT that sold for $69 million, you own that one NFT and that's yours. You're not relying on Beeple to make you money or Sotheby's or anybody else. The NFT is the value proposition, not what it represents. A share of stock on the market is fungible, right? We don't care which share of Apple or Tesla or IBM you own because they're all the same if they're listed. So the NFT world really has something there where it wouldn't be a security if its value is only derived from the NFT itself. When you start getting into issues about multiple, drops or drops where you're issuing thousands or tens of thousands of the same exact thing, then I fear in the future, just fast forwarding a year or two, somebody's going to get one of these new enforcement personnel calling or writing them a letter saying, we really think your NFT is a security and you didn't register it and you don't have a valid exemption because you didn't screen for accredited investors in the US, you didn't put a one-year hold on it, and you're not being issued to offshore non-US persons. So you failed Reg A, Reg D, Reg S all at the same time, you haven't registered it, and you're out of business. So that's the rub there, but I think that NFTs in general would generally are getting a pass from the Howey issues.
Yeah, so I think these platforms that issue NFTs in bulk and thousands in series are probably exacerbating the issue. So first and foremost, I would say we need new platforms that are enforcing or helping to navigate like where it is a security, where it's not a security. And I know that there are a few platforms out there that are working on kind of NFTs that are securities, and that's great. In terms of just offering utility and common enterprise, there's so much business to be had in the NFT space where it actually is the use of property, use of equipment, trade agreements. There's just so much out there, but the way we structure them, and that's why SolidBlock is doing that now for clients in hospitality that have requested that. The way we're structuring that from the beginning and the way we're listing that on these platforms need to be completely different, right? So that there's no suspicion that it is a security.
Yeah. So, other Brian, we in the U.S. tend to be very knowledgeable about U.S. laws and not so knowledgeable about other jurisdiction laws. But you actually have studied the laws of many jurisdictions. So maybe you could spend some time, giving us a little overview of, some of the more prominent jurisdictions, as it applies to tokens and securities, and maybe help answer, if Pokemon made NFTs, would they be securities or not?
Thanks, Joe. So I'm admitted in 3 jurisdictions, but have no practicing certificate right now. So I'm not giving any legal advice here. It's always interesting coming back to New York to hear the depth of the analysis, but let me take it back a few steps. So there are securities regulators in every country around the world, right? They're all grappling with similar issues with different levels of sophistication. So of course, securities analysis is certainly one of them, but there are also lots of other, many countries like the US have got multiple regulators, but some countries only have a single regulator. So when they have a universal regulator, they can actually look at it from a more holistic point of view rather than saying, okay, should it be SEC, CFTC, you know, the Fed, who should actually, but yeah, I'm based in Hong Kong right now, and we have that regulatory arbitrage question internally. Is it the SFC? Is it the HKMA, right? So this is not new. But I think what I would add is a few general thoughts. So first and foremost, securities regulators ultimately, as you've heard, again with the current chair, is about protecting investors. Now, I think what I find curious and very interesting about the space here is as follows. So I think the organizers here also started with what I was interested in, which was crowdfunding. So I was in New York and wanted to go back to Asia, and the partner said, Brian, you're kind of entrepreneurial. Will you help set up the Palo Alto office? So that's when I was in Silicon Valley during the dot-com boom, pushed out 4 IPOs and it went down the other side, and securities suits followed thereafter. So had an early experience there. But the thing is that there is the regulators are there to protect individuals. Now the question becomes, so ICOs came about trying to democratize, and equity crowdfunding tried to democratize it, which is great. The question is, how much do moms and pops need the protection? And I think that's where there's a debate in the community as to how much you feel they may need to be protected. But as the space evolved, and that's why some of us tend towards and have interest in the STO space, is suddenly everybody wants instos. Now, if you want instos, they don't need protection, right? They have different kinds of interests, but there are different kinds of instos, as you would know. You've got the big traditional long-onlys, but hedge funds are instos too. And so are family offices, right? And so are ultra-high net worths, and so which Asia has a lot. So suddenly you have different levels of considerations for each of those. And again, the more institutional, the other kinds of considerations there. But therein, if you think about the ecosystem, and I love what was shared earlier on about community. So we've got the sponsors, as we've heard, who are then whether the ICO, the STO sponsors looking for the right product to come out. But increasingly also, and then you've got the structurists, people, because they're not just equity, they're kind of debt-like too, or maybe they're mezz-like, or they're a new token, it's a new kind of asset class. But you also have traders. So the traders are the ones that talk about stable coins, and they're so important for their ecosystem, but you know, those that work in the other space, the long-only type investors, like, they don't consider those. So there's so many facets around the development of this. I think the part that I would add also is, so that's one aspect, but the other one is regulatory arbitrage. So again, it's great to be back here in New York, but outside, I joked when the ICO realm came about, and I had somebody from Davis Polk sitting next to me. I said, normally what we'd just do is do it Reg S, right? Just exclude the US. But of course, people want to tap the US markets. But how do you do it properly? And I think, so there is an interest there definitely to come and tap the deep US markets. But by the same token, you've got, pardon the pun, you've got Hong Kong, you've got Singapore. We used to have a slew of island nations come and developing their ecosystems. Now you've got the Middle East that's really growing as a center. I mean, I was just reflecting upon somebody who was saying that they, at the Super Bowl, you now have 2 big cryptos that have got stadiums, right, named after them. Guess where both were founded? Crypto.com and FTX were founded in Hong Kong, right? But can we keep them? Do we want to keep them? Right? So there are all these factors that are coming into play when you think about the evolution of regulation. So I think I love what Wyoming is doing. There are lots of really interesting innovations coming out in the securities world, but there are also lots of other kinds of regulations because, again, all of you are from different parts of the ecosystem. Suddenly, are you a registered broker-dealer or the equivalent there? Are you a custodian? How are those regulated? Are you a money exchange, right? So all these countries are developing different. Are you an exchange? So Hong Kong is creating its new regulations. A lot of it is FATF based. So FATF, love it or not, KYC is legitimizing the space. So new regulation is coming through the Ledge Code this year in relation to that. So for better, for worse, I would say, Hong Kong currently doesn't have an opposition in Ledge Code, which means regulation can go faster, for better, for worse, right? But you also have Australia now looking at new regulations. Singapore has got, they've been granting more licenses, but controversially or otherwise have said we want to be a responsible jurisdiction. So there are certain large players that have not gotten licenses there. So I think this is a fast-moving space. I think interestingly and importantly, I think we all agree, especially in this space, we don't want to race to the bottom. Right? We want legitimacy in the space. We want to have good players. We want to have great projects. That's what we want. We want to have interoperability so that we can have individuals, institutions around the world to be able to access those great projects. How can we come and find a way forward? A last little thought I would add is that so the current head of IOSCO, which is the global regulatory body or if you like, the think tank that overlooks all the securities regulators, is also the head of the SFC, which is the Hong Kong's regulator. And so one of the predictions, he actually used the phrase, the 3 C's. I think, there's crypto, climate, and COVID is what people are now focused on. And he's hoping that there will be more interoperability amongst the regulators going forward. So maybe I'll stop at that for now in terms of some of the developments around. So I think at the end of the day, what we ideally would like is more interoperability, not just amongst the protocols, but also amongst the regulators.
Yeah, well, that's actually important because, these laws are regional, in their creation, yet the whole purpose of crowdfunding and, the ethos of crypto and decentralization is global. So what is this, to avoid regulatory arbitrage? And I don't know if you ever can fully get past that. There will always be some ambitious nation state that will try to be a little bit friendlier. How is that balanced now? We see some interesting structures out in the marketplace where people are trying to have their cake and eat it to avoid the U.S. but get the U.S. security maybe outside of the U.S. but no one cares and not a security in the U.S. Are there structures that you guys like? Are there jurisdictions that you really like for this sort of stuff?
I love Wyoming.
Yeah, and talk about Wyoming. Actually, Wyoming, which I can't even Google what the population of Wyoming is, but they're a leader in the crypto space here. What's Wyoming's role and how do their laws kind of think about security tokens and how does that play out to an issuer that actually wants to go after the nation or the world?
Well, the actual genesis of all the blockchain legislation in Wyoming is essentially jealousy after Delaware adopted its LLC legislation in 1978. Wyoming has never lived down the fact that it came up with the LLC and people have instead used Delaware. On the other hand, the state has an economic development plan to recalibrate its economy from oil and energy into high tech. And the state is uniquely positioned to take advantage of that because we have a lot of well-educated people who worked in the oil and gas business. This was not something that was done willy-nilly. This was the product of months or years of discussion with the legislature. And we were talking about nation states. I guess the nation state of Wyoming has one of the more effective legislatures, I would say, in the 50 states. We have 30 senators, 60 House representatives, and just about every one of them were involved in the first round of legislation, and then ultimately became more and more involved in developing the laws and regulations that they sought to put together to create an ecosystem that would not only facilitate whatever all of us in this room want to do, but also to create jobs within the state of Wyoming. Now, the problem we have with that, of course, is the message. I mean, the state does a very good job of trying to say all the wonderful things we can do. You can create a captive insurance company with crypto. You can issue debt with crypto. You can do secure transactions with crypto and file a security interest with the Secretary of State. All that's great. The problem is that how do I convince everyone in this room, for example, to become part of the largest exchange in the United States, which is actually the state of Wyoming, because of its intrastate regulations. Everybody in this room, if they had a Wyoming LLC, trust, or partnership, could trade with one another and not even really worry a lot about the SEC. They could do that. And that's a hard message to get across to people when you're dealing with somebody who wants to buy $20 worth of coin. You know, the sophistication goes up a notch. So the state has actually had to recalibrate a lot of its expectations. But I think I think there are other states that are trying to follow. I don't think they'll be as successful as Wyoming. Wyoming is actually, there is a pilot, as I think, Jor, you know, they're trying to digitize land title in Wyoming. Teton County in Jackson, the first one is to make an effort. Be careful what you ask for, because if you're, you know, I know the state of Wyoming, for example, had issues with going back to finding title when the state was a territory and trying to track when when land and title had all passed and putting all that on the blockchain. I can't even imagine what that would be like in New York going back to, what, 1662 or something. But that's the kind of granularity that some of these ventures that we think, you know, will ultimately facilitate all of these wonderful things we want to do. But there's a lot of hard work to do. And I think Wyoming's role is to be a governor or a demonstrator of the things that have to be done for all of this stuff to work the way we want it to.
Yeah, there's no question Wyoming has been really kind of leading a lot of the regulatory changes in the US and just awareness and getting other state regulators to kind of think critically about this, and even kind of nationally.
Can I speak to that just a little bit?
Of course.
So I think, you know, everybody wants to be, because we're in New York here, everybody wants to be the new Wall Street, right? So whether it's Wyoming or any nation, lots of nation states around the world want to be that, right? Because this is the new horizon. So I moved to Hong Kong because it's one of the top 3 IPO centers of the world, right? There's doing a lot of the major IPOs there. But so in some ways, places like Hong Kong and London and New York have the most to lose, right? Because it already has that base, so it can't get the regulations wrong. Whereas you've got other locations like Singapore. So I love your analogy, because in some ways, you're creating the exchange. So on the one hand, a lot of them want to attract all the insto money there, right? But on the flip side, they also, if they're a large enough population, they don't want retail to get burnt either, domestically, right? So I think that's one thing to think about, in that, you know, everybody wants to be the new Wall Street, and they all want to attract all of you to join that new Wall Street.
Just very quickly, unfortunately, Wyoming, with all these advantages that it has, doesn't help us very much when we go out to market securities, because you go by the regulation of where the investors are located. Very few of them are in Wyoming. But just another thought, the jurisdiction we don't like is New York. They're very, very difficult to operate in. We have an address in New York, considering to change the address to Miami. You know, guys, if you're close to legislators, get them moving.
So Wyoming did a great job in marketing a pro-crypto agenda. One of the things that I love is they actually amended their LLC Act to allow you to designate yourself as a DAO. And one of the biggest issues with DAOs on the legal side is this notion that it's not an LLC, and you may have general partner liability, meaning that any member of the DAO could be responsible for the debts of all of the DAO. And so that's what's really stifled a lot of the DAO growth. Wyoming changed their statute to allow you to be a DAO and have limited liability protection, which is great. And then Tennessee did that, and then Delaware has done that as well. The problem with Wyoming is that it's in the US. And for securities regulation purposes, you know, the SEC has federal preemption over the enforcement of the Securities Act. The good thing about the SEC is that it's slow to change, and that's also the bad thing. So I don't think that any of the bills that Congressman Emmer talked about, no matter how they dress it up, the Securities Clarity Act, you know, we're never going to see enough attention from the mainstream agendas, either on the Republican side or Speaker Pelosi, to get those pushed through. Things just happen too slowly. But the SEC does have rules which allow you to sell securities offshore to an unlimited number of persons for an unlimited amount of money, as long as you don't conduct directed selling efforts into the U.S. And there's nuances there about how much can be U.S. and non-U.S. And you don't have to have a holding period. So if you look at all of the coins that are now listed, most of them had their genesis in the British Virgin Islands, Cayman Islands, Gibraltar, Mauritius, Liechtenstein, you name it, Bermuda, and they've come back to the U.S. magically, and there's no real regulation on the secondary market. The only regulation is on the primary side. So when I'm selling my token, that's a regulated activity. If I do it offshore through an offshore affiliate, then that's outside the purview of the SEC. They've acknowledged it. They have a whole regulation called Reg S, which acknowledges that it's offshore and outside their purview. So I think that that's a path that unfortunately leads a lot of people outside the U.S. And you know, meanwhile, all these companies are here, and they have service agreements, and they have other types of ways to get the cash back on shore. But it's an interesting quagmire because, you know, to have real regulation, have real clarity, and really protect people from losing their money, which is, you know, an admirable goal of any regulator, especially the SEC, they need to be proactive. They need to see things happening. They're in a situation where they have regulators on either side of them that may or may not be the right regulator for that product. And I think they're slow to act because they don't want to make a mistake or do something that's so narrow and short-sighted that it becomes outdated 6 months later. Right, and so I think that that's kind of the situation we're in. Howey Test is good law. It's not going to be overturned unless there's a case that comes to the Supreme Court that overturns it. Maybe now the Supreme Court's willing to overturn precedent, so we'll see a challenge to Howey. But you're going to see a commission that's not going to be very proactive unless there's a driving need to do so.
Right. We have 50 state regulators plus the territorial regulators in Puerto Rico and, you know, American Samoa and wherever. We do have to remember, though, that we are, you know, this is a federal country is federal. It's jurisdiction. You know, what isn't you know, constitutionally, whatever isn't taken by the feds is given back to the states. You know, there is a reason we have 50 state securities regulators, because they enforce state securities laws. And there is an interest in these state regulators facilitating business, facilitating commerce, and actually protecting the people that are in the state. I mean, one of the things that's interesting in Wyoming that you may not know is that you know, there are intra-state exemptions for securities offerings, and Wyoming actually has its own crowdfunding statute. You know, that you can do an intrastate crowdfund. I mean, think about that for a second. You know, using an LLC or a trust or a partnership. Yes, the SEC, if you're wiring money and, you know, they want to find that you're using interstate means of commerce, fine. But if you're looking for a safe harbor and you're looking to try and find a way to offer what you want to offer, I think the states probably have more traction in terms of getting regulation to fit the needs of the people in this room than the feds ever will.
And the blue sky laws will prevent anybody from doing that, though.
I don't even know if I should ask this next question. It's kind of ambitious, but we have a little bit of time, so I'll try. So we talked a lot about a lot of regulation being on the primary markets, right? But a lot of the promise of tokenization is the secondary market. And right now, of course, you've got secondary markets that are these kind of unregulated exchanges, but centralized. You've got some that are decentralized. You've got some that are centralized and registered, like ATSs in the US. And then you've got national exchanges, right? T0, for example, has got an ATS and a national exchange, right? So when the SEC comes out and kind of suggests that they might expand the definition of exchange, what does this mean for the ecosystem? Like, what's the impact for this, other than, you know, maybe some people with licenses grinning?
So the SEC has made a rule proposal that the definition of the word exchange will be modified. It's in the back of a release that is titled something about treasury bills, which is not what it's related to. And an exchange will include communication protocols and about 10 or 11 other titles of words that sound very similar to that. That is a thinly veiled attempt to rein in anybody who is posting pricing information or posting information about who is selling or where you can buy. I think they're fed up with the status quo. I don't think that the secondary model is acceptable to them. If you look at the secondary pages, it looks like 2,000 tokens have IPO'd overnight with no disclosure, no financials, no management, no MD&A, no risk factors, and nobody even knows their address or what these things do other than the white paper. So that will happen. It was a very short comment period for a 600-page release, and a communications protocol that is not regulated is going to have to find a way to either partner with a broker-dealer and an ATS, form its own broker or ATS, or alter their activity in a way that complies. But I think that having a parallel world of the regulated market and the unregulated market is not something at the current level of capital that it's attracting that's acceptable to the SEC. And I don't think any degree of First Amendment or other comments about is going to hit any kind of traction inside the commission. That's my
James,
view.
maybe one comment and then we got to cut it.
Very briefly. But I think that's a trend globally, right? Because everybody's now realized, these old regulations don't actually address the way that the world currently works. So there's a trend around, virtual asset service providers. Again, this is a FATF term, but the different countries now passing service provider regulations to try to regulate these different service providers in this new ecosystem. So I guess all I can say is watch this space. It is an evolving trend.
Great, thank you everyone.